Buenas. What would you do if you bought a piece of property, then you find out it belongs to someone else? Some may call that a land scam. But what if everything about the sale and the purchase was legit? You got a report that shows a certificate of title without encumbrance from the seller. At every push of a stamp in the Guam Department of Land Management, every legal document was accepted and recorded. You paid for it, you own it. And then GovGuam takes it. Enshrined in the U.S. Constitution under its Fifth Amendment is the clause that no private property shall be taken for public use without just compensation. It's one of those precepts of our republic that separates the modern world from communism and totalitarian rule. As with every great land scam on Guam, and land scams have been going on here for centuries, there's a long and sordid backstory to what is perhaps the most significant land dispute in this region in decades. This is the Harmon Annex, just meters from Two Lovers Point. Decades ago, the U.S. Air Force built a sewage system on a small tract here that eventually began to pump raw sewage out into the Philippine Sea, which is just beyond the cliff here. In the 1970s, President Nixon created the U.S. Environmental Protection Agency, and even the military could not dodge its oversight. In 1980, the Air Force leased the property that would become known as Lot 10184-7 to GovGuam for the improvement of a Northern District wastewater treatment plant. Governor Paul Calvo signed the general purpose lease in February 1980 for a term until 2005 with one option to renew for another 25 years. In it, the military was indemnified from any liability arising from the property. Then in May that year, the federal government granted GovGuam an easement to the property. The environmental and capacity concerns were non-existent to minimal at worst throughout the 1980s until the economic boom and the rise of the Tumon Visitor District and the housing construction in Dededo and Jigo began to take its toll. On October 6, 1994, the young freshman congressman from Guam, Robert Underwood, secured the passage of Public Law 103-339, the Guam Excess Lands Act. More than 3,200 acres of prime property, about 10% of which encompassed the Harmon Annex, was returned to Guam with a caveat that lands had to be used for a public benefit. In the Senate report of that statute, Congress made clear that returning the land to its pre-condemnation owners did not constitute a public benefit. Then Governor Joseph Atta reminded the 22nd Guam legislature of this fact when he signed Public Law 22-145 on December 29, 1994, days before leaving office. That law made it the policy of the territory to give those 3,200 acres to the heirs of the pre-condemnation, or what we know as the Ancestral lands owners. At the time, the lands were given to the Chamorro Land Trust Commission for proper disposition. Then on July 23, 1997, following the creation of the Guam Waterworks Authority to replace the Public Utilities Agency of Guam, GovGuam executed a grant deed with GWA, turning over all water and wastewater infrastructure properties to the Autonomous Water Agency. Page 32 of the deed identifies the easement and the Northern District Wastewater Treatment Plant as among the properties given to GWA. 5 pages later, the grant deed specifies that GWA, quote, expressly acknowledges the provisions of Public Law 22-145, Public Law 23-23, and Public Law 23-141, end quote. The grant deed required GWA to covenant that all provisions of those laws will be respected in accordance with the land disposal requirements of said laws. Public Law 22-145 is about the return of the lands to the heirs of the pre-condemnation owners. Public Law 23-23 contains a provision that states if any of the land to be claimed by ancestral claimants already are under public use, quote, in such circumstances the government of Guam shall make good faith efforts to derive a means of compensation for continued public use of such lands, unquote. These laws, created in the visionary days of both the Atta and Gutierrez administrations, represent the lion's share of public land policy on Guam. And every elected official on Guam, from our congressmen and former congresswomen to our governors, to our senators and attorneys general, have all been on the same page, defending the so-called rights of the ancestral land claimants and private property owners until very recently. We'll get to that story another day. Back to 1997, when GovGuam granted the property to GWA. 2 years later, on June 9, 1999, the legislature created the Guam Ancestral Lands Commission and placed title to all the lands CLTC was to return through the Ancestral Lands process into the Ancestral Lands Bank. In 2001, the U.S. EPA sued GWA for, among other things, dumping raw sewage into the ocean. In 2004, following due diligence and a succession of legal documents and processes, the GALC quit-claimed most of the Harmon Annex to the heirs of its pre-condemnation owner, Jose Martinez Torres. Over the next 2 years, the Torres estate sold most of the properties, including Lot 10184-7, where the Northern District Wastewater Treatment Plant is located, to Unix, a developer. In 2006, the State Department announced an agreement with Japan to move Marine forces off Okinawa and reposition them on Guam in a major global realignment of the U.S. Armed Forces. Underlying the movement is the commitment to improve just one piece of civilian infrastructure, the Northern District Wastewater Treatment Plant. By representations made by the U.S. government, the government of Japan is made to believe the property where the plant sits is free and clear of title issues. In 2008, surveyor Frank Castro drew up and recorded a map that included the boundaries of Lot 10184-7 and the surrounding lots within the Harmon Annex. In 2014, Deputy Registrar of Titles Andrew Santos issued a certificate of title showing Unix owned the land where the Northern Wastewater Treatment Plant is situated. That same year, Cortec International acquired all of Unix's Guam holdings, including Lot 10184-7. By this time, GWA was going out into the bond market to borrow money to, among other things, improve the island's sewer system. They never disclosed to creditors that there is an issue with their most valuable asset, Lot 10184-7. In 2017, in a vain attempt to remedy the matter, GWA commissions Duenas Camacho and Associates to draw up and record a new map of Lot 10184-7. That map moves and extends the boundaries of the property. In 2018, Michael Borja, then Director of Land Management, sued CTI in the Superior Court along the premise that his agency erroneously issued a certificate of title that essentially shows CTI owns Lot 10184-7. For all the years CTI owned the property, and even through the first days of the litigation, the developer did nothing to stop or so much as interrupt GWA's operation of the sewage treatment plant. It wasn't until GWA bulldozed CTI's fence line and encroached on an acre of the surrounding property that Cortec had enough. We spoke with CTI executive Henry Titano, who took us on a tour of the Harmon Annex while construction on the treatment plant was ongoing.
So we're heading into the like what we call the equipment yard and our concrete batch plant area. There's another entrance that we can take as well, but going this way right now.
And what's this property over here?
So I mean, this is all vacant land basically. That's within the
lot?
gated area. If you look at it on the map, the entire 250 acres, right? The 101.4 is -7 is a portion of it.
Yeah.
So when you hear about the land being sold to Yonex from the Torreses, this is what Yonex did with the property. They started building all these structures. So what we've done is we kind of completed them internally, and because it was vacant for a while.
This is the worker housing.
Yeah, when the buildup was delayed, and you can see straight away you're actually looking at the treatment plant project.
Okay.
So
this right up here is 10184-7.
Yeah, we're basically.
And this is the workforce housing, and there's the concrete batch plant.
This is our concrete batch plant.
Okay.
We have to.
So the property is just right next to each other.
Yeah, I mean, it's basically part of that part of the property, and I'll show you. So what happened was, when they started doing this project, there was a time when they just broke down the fence here and decided to extend their property line.
Okay, where was the fence?
Right, so we're looking at it right here.
So that's the new fence right there?
Yeah, so we're gonna drive along the right. Well, I mean, I would think they went through the permit process too, right? So
they would have to go through the same sort of permitting process that Cortec
well,
batch plant.
Well, one of the things if you go into the GWA records, you'll notice that you know, they actually were paying for surveying, for land management, for the property. I think they're even paying for the legal bills that are associated with the lawsuit. So it's kind of interesting because, you know, land management, ancestral lands, there are mandates, right? They're supposed to be more protective of local landowners, not necessarily getting on one side or another, especially with the utility and when there's federal government involved. It kind of seems contrary to what they're enabling activities, right? When the property was given back, I think the federal government was actually using it as a quarry because it was already a quarry.
Okay.
So yeah, I mean, you know, obviously we're filling it and then using it to have materials so when you do excavation on properties and stuff like that. But the contractor in DPW and GWA were basically wanting to use this road to bring their dump trucks and stuff to the wastewater treatment plant project.
Okay.
And you know, also, this is also Cortec property. So the reason we had closed this area off was because we had equipment here, and you know, this is a dark area.
This is dead.
Yeah, so you know, it could be vandalized and stuff, and it's expensive equipment. Well, they came with like DPW to like basically threaten to impose, you know, fines or something on us, and so we had to remove our barriers. And once we did that, then obviously what we expected to happen happened. There was vandalism. Our equipment was vandalized. You know, and so see this.
This is where it was
Yeah,
blockaded?
so this is where we were blocking people from kind of entering, and they made us move these barriers, saying that it's not our property, right? And so, you know, now we have to deal with it in court. But you know, basically.
Is this a separate court issue or?
Well, I mean,
all
it's just
part of it?
all part of the same issue, right? So, you know, it has to. The basis of the entire issue is who owns the land, and you know, the government of Guam was accepting property taxes for the land, and now you know.
And they have their own. They have their own easement to access their property, right?
Well, they
It's
can
from
do it through like the Two Lovers Point Road,
yeah.
right? And there's no reason they can't do it through there.
So it's not like they were being blocked.
No, I mean, it's for them. It made it more convenient for their project, and I think that, you know, they wanted to maybe minimize, you know, because if you go that way, how you turn onto Route 1 versus how you do it this way, it's a lot easier.
But is this a public?
No,
It's not. This is part of Cortec's
In fact,
property.
GWA was trying to get Cortec to allow an easement while this is all going on as well. It's kind of.
What are we looking at over here? This is the northern wastewater treatment
Yeah, so
plant?
basically this is the expansion, and I think you know, it's a large project, and I think part of this too might be the property that they acquired for like the GPA solar plant or something, the 180 megawatt. Remember that story?
Will you happen to know where the 20-foot easement for the pipeline to Camp Blas is at?
Oh yeah, I think so.
Oh, there's a new water treatment facility
Yeah.
right there.
Yeah. So the easement is like in here more, but I think there's a side entrance I can show you.
No, that one was never in dispute, right? The 20-foot easement. At least that's what my understanding from the documents.
Yeah, I mean,
That forever belonged to or was assigned to the United States government or something like that.
well, you have to think about it, right? So all of our wastewater in northern Guam goes to this treatment plant.
Yeah.
So even Cortec would be hurting itself if it tried to shut down the
Yeah.
treatment plant. That's not the point, right? The point is how they treat land rights, and you know,
And the encroachment. The encroachment is a big issue.
it's a huge issue because, you know, in order to finance any sort of property development, banks require, right, you have the, you know, fee simple right to the land, or at least a leasehold of some sort, right? And if you don't, then, you know, you can't really utilize the land. So giving land back to local landowners and not allowing them the full land rights is almost like giving them property taxes. That's it. That's all you're doing. You're just putting them more in debt. You know? And a lot of the local landowners that received land back from the local government because of the federal government return, that's why you don't see them developing a lot of their property too. Is because it's not like these people had a lot of money, and they could just say, oh, we have property now, we have, you know, all the resources in the world to feed our families. I mean, even during the GLUC process for the batch plant, when we met a lot of the local landowners in the area, they shared their concerns. They're like, we just want to be able to at least use our land for something, because we don't have a lot of money. And one of the things we explained to them is we bought 250 acres here. We didn't buy 5 acres. So it's in our best interest to preserve the value of the property in this area, right? So, just like what we did if you think about like Okatamuni, it was a big eyesore, right? The 4 towers, and, had an impact on property values. And now we've completed the project. It's a beautiful place, and we didn't even make it as dense as it was planned. And, the outcome is you have better property values in the area for those who own houses there, right? So as a private company, we're always going to act in the best interests of our investments, and that's why we're good neighbors, because whenever we invest in a village or in an area, the adjacent landowners, there's going to be a benefit for them. We're going to develop it. We're going to enhance the utilities, and that's what's kind of a shame about what GWA is doing, is that they're kind of leading this charge against a local landowner, and they're supposed to be, a local government entity. Right? The Ancestral lands as well. I mean, that they made that deal with GWA and they sold the property that wasn't theirs. And the whole purpose of Ancestral lands is to protect local property rights, right? So that's,
I need to call land manager.
the whole purpose of PRAT, right? When you do base relining and enclosure, the reason why it's done the way the federal government has it set up is because they know that there's a social economic impact to the community, right? So like, for instance, closing of SRF, we lost, thousands of families went off island, right? Local families, because of the jobs. They lost their jobs, and so they had to leave island, go find work elsewhere, and it was a huge social impact to Guam. So when the federal government does those sorts of things, it's supposed to mitigate its negative impact, obviously. And so things like affordable housing, those sorts of things are kind of like mandates within the BRAC law, the federal BRAC law, so that the military going in and out of the community doesn't just become such a huge detriment to the actual community, right? Because of whatever their defense strategy is at the time. You look at this area and where this is happening right now, this is one of the most poor census tracts in the entire island, right? This whole area here. You're looking at the Ukudu area and, Dedido in general, right? Now you look at affordable housing, there's a greater need for affordable housing. So all of these impacts, right? Crime, housing, all these things, where that Guam struggles with, it's like very concentrated in this area, and it's the worst place for the local government to not kind of jump, to defend our citizens and our business owners. This is where they should really make their stand, right? I mean, when you talk about, what opportunities we may have, despite without the buildup, or this is where you could make that stand. And what's unfortunate is it kind of seems like the utilities are just, acting in the interest of the utilities, and it's not necessarily the local resident or citizen, which was the intent of like laws that created ancestral lands and those sorts of things, that's really being thought about, right? I mean,
Those are the
you brought up a
questions
good
that we
issue.
have.
You brought up that good issue, and I heard Tootsie talk about it, was, what does this mean for all the other properties that might have that reversionary clause?